Let's bring in MSNBC's chief legal correspondent, Ari Melber. Ari, good morning to you. Let's play this out. Two of the key intelligence officials, Mr. Coates and Mr. Rogers, have already said that they didn't feel, and they said this under oath, that they were not pressured to end any kind of investigation. So is this obstruction investigation now going to boil down to the word of James Comey versus the word of the president?
Probably not. And that's because the DOJ doesn't care about their feelings and the way they put it in that now famous testimony. The DOJ cares more about the feelings and intent of the president. This is by far the largest development legally in the Trump era. It is a sign that the inquiry is not just about the campaign in the past. It's a criminal inquiry into the president's conduct in office, the present.
And how is that likely to proceed? I mean, in a normal investigation, one might try to get the testimony of the person you're investigating. Could Mueller conceivably get the testimony of President Trump under oath? Could it set up a situation where the president could say, I don't want to testify because of privilege or because of the Fifth Amendment?
All of those things are possible. Previously, we have seen prosecutors or independent prosecutors seek testimony of White House aides, of senior officials, and get it. Grand jury testimony tends to be something that's hard to resist. But when President Clinton was ultimately faced with this, and we're not there yet, they agreed voluntarily to do grand jury testimony under oath. Whether a president would not agree and be forced is a legal question that has never been answered.
All right, Ari Melber. Ari, thank you very much.
Hello, Today fans. Thanks for checking out our YouTube channel. Subscribe by clicking that button down there and click on any of the videos over here to watch the latest interviews, show highlights, and digital exclusives.